Hello and welcome to ProfDale's Property Video number 22. I'm your host, Dale Whitman. In this video, we're going to consider the following topic: the distinction between leases, contracts, and licenses. Let's begin by thinking about the nature of a lease, an ordinary commercial lease between a landlord and a tenant. What's the nature of that transaction? Does it convey an interest in land, or is it a contract? Well, if we think about it for a minute, we'll realize that it's both. A lease contains a conveyance between the landlord and the tenant, where the tenant receives the leasehold estate from the landlord. It's similar to a deed in that respect, except that the estate, instead of being a fee simple, is a leasehold estate. But the lease also contains a variety of covenants or promises made by each party to the other. The landlord promises things to the tenant, and the tenant promises things to the landlord. So those mutual covenants make the lease into a contract as well as a conveyance. Now, there's an important principle of contract law which traditionally has not been applied to landlord-tenant relationships. In contract law, we say that the covenants of the contract are dependent. What that means is that if one party to the contract commits a material breach of the contract, the other party can walk away. They're discharged from the duty of further performance. That's a principle that we're all familiar with, and it seems perfectly natural. However, traditionally it hasn't applied in landlord-tenant law. In landlord-tenant law, the covenants are treated as independent. That means that if one party commits a material breach of the contract, the other party can sue for damages for the breach, but is not discharged and continues to have a duty of performance. At a very early date, landlords realized that this rule of independence of covenants was a very bad rule for them, because what it meant was even if a tenant quit paying the rent, the landlord had to continue allowing the tenant to remain in possession. Well, that seemed kind of nutty to landlords, and so they solved this problem in two different ways. The first way they did it was by getting the various state legislatures to pass statutes that reversed the rule as it applied to landlords. Here's a typical example: a statute that says if there's material noncompliance by the tenant with the rental agreement, the landlord may deliver a written notice to the tenant specifying the acts and omissions constituting the breach, and that the rental agreement will terminate on a date not less than 10 days after receipt of the notice if the breach is not remedied in 10 days. Now, this particular statute gives the tenant a 10-day cure period. Not all of the statutes do that. Some of the statutes even allow the landlord to terminate the lease preemptively and immediately because the tenant has committed a breach. But either way, you see the idea is that the landlord doesn't have to allow the tenant to remain in possession if the tenant fails to pay the rent or commits some other important breach of the lease. The other thing the landlords did was to put similar language in the leases themselves. Here's a typical example. If tenant fails to pay the rent when due or breaches any other covenant in this lease, landlord may immediately enter and terminate tenant's estate. So both through the state statutes and through clauses in the leases, the landlords protected themselves against that rule of independence of covenants. Now, you might ask the question, couldn't a tenant insert a similar clause in a lease that gave the tenant the right to terminate the lease on account of the landlord's breach? Well, the answer is, in theory, that could work just fine, but in practice, it's really quite rare for a tenant to include such a clause, and in negotiating the lease, one might expect the landlord to object strenuously to the inclusion of such a clause. Now, the independence of covenants doctrine has never made very much sense, and I'm happy to report that it is losing ground, mainly because of the adoption of the Restatement of Landlord-Tenant Law, which was published in 1977. Here's what Section 7.1 says: except to the extent the parties to a lease validly agree otherwise, if the landlord fails to perform a valid promise contained in the lease, and as a consequence thereof the tenant is deprived of significant inducement to the making of the lease, and if the landlord doesn't perform that promise within a reasonable time after being requested to do so, the tenant can terminate the lease or continue the lease and recover damages. but the importance of the section is it allows the tenant to terminate the lease if the landlord commits a material breach. Now, a number of states, Arizona, California, Delaware, Massachusetts, New Jersey, Pennsylvania, Utah, and Virginia have adopted the restatement. Even in states that haven't adopted the restatement, we will see as we go on through the remaining videos that the doctrine of independence of covenants does not always apply. There are some standard landlord-tenant doctrines that disregard the independence of covenants concept. The doctrines, which we'll study later, include constructive eviction and the implied warranty of habitability. Now let's turn our attention to a new topic. We need to realize that the right to occupy somebody else's real estate is not necessarily governed by landlord-tenant law. There are, as it turns out, lots of other possibilities that can explain why someone is legally on someone else's land. Let's take a look at some of the non-landlord-tenant rights to possess real estate that exist in our legal system. We'll say just a brief word about each one of them. The first one is the mortgagee in possession. That happens when a lender goes into a borrower's property to preserve it from the elements or to prevent vandalism or to secure it. They take possession of it, but they're not a landlord or a tenant. A second example is a real estate contract purchaser, someone who's buying land using a real estate sale contract and who goes into possession before they have legal title. It happens quite frequently. A third possibility is an innkeeper-guest relationship. Everyone who's stayed in a hotel or a motel has been involved in one of these relationships, but they're not landlord-tenant relationships. Another possibility is a sharecropper, someone who farms a property that doesn't belong to them, and instead of rent, they share the crops that they raise. Another possibility is an employee-employer relationship, such as we have when we go to work. The final one, and the one that we're going to spend most of our time thinking about, is a licensee. Now, this doesn't refer to a license to drive a car or to run a saloon or any other kind of written license. A license in this context simply means permission to occupy someone else's real estate. We have these licenses all the time. For example, when you go into a store or a shop, you go to the movies, you go to a restaurant, you're on someone else's real estate. You're there with their permission, and therefore you are a licensee. One of the trickiest issues in American property law is distinguishing between leases and licenses. Let's suppose, for example, that you own a house and you invite your girlfriend or boyfriend to move in with you. Do they have a license, which means they don't have an interest in the land at all, or are they a tenant under either a periodic lease or a lease at will that would give them an interest in the land? Another interesting question is a corporate skybox at a stadium. Corporations pay lots of money for the right to use those skyboxes. Do they have leases or licenses? One other dilemma is, suppose you list your house or your condo with Airbnb. People come and stay there. Do they have a landlord-tenant relationship with you, or are they merely licensees? None of these questions are easy to answer. However, there are some factors we can look to help us distinguish between leases and licenses. Here are some of the factors. First, is the duration of the occupancy short or long term? The longer the term, the more likely a court is to find that it's a lease rather than a license, because so many licenses are for very brief periods of time. Is there space that's specifically designated for this occupant? For example, if the agreement between the parties says that the occupant can be moved at the landowner's will, we can move you, for example, from one skybox to another or from one parking space to another. That's more likely to indicate that it's a license, because a lease, by its nature, involves possession of some specific piece of real estate. Another question is whether possession is exclusive. If the landowner can walk in on the occupant at any time freely or otherwise disturb their possession, a court is more likely to find that it's a license rather than a lease. Finally, is there payment being made by the occupant? If the occupant is there for free it's more likely that the court will find a license. If the occupant is paying, it's more likely that the court will find a landlord-tenant relationship. What's more, if the parties call that payment rent, that's a very strong indicator that the parties intend a landlord-tenant relationship. Now, none of these factors alone is dispositive, but the court is likely to consider all of them in an ambiguous situation. By the way, what the parties call it, whether they say it's a lease or a license, doesn't necessarily resolve the question. Now, you might ask, why do we care whether this is a lease or a license? Well, let me give you just a few of the situations in which it could make a big difference legally. First, taxation statutes. For example, sales taxes may apply to one but not the other. For example, frequently sales taxes don't apply to landlord-tenant relationships. Another possibility is that the notice required to terminate the relationship or to evict the occupant may be very different for landlord-tenant relationships than they are for licenses. Another possibility is that the tort liability for injuries to the occupant may be very different if it's a lease than if it's a license. The statute of frauds, as we've already seen, applies to leases as long as they're for a duration longer than 1 year. In general, however, the statute of frauds doesn't apply to licenses at all, and an oral license is perfectly enforceable. Compensation in eminent domain, if the property is taken in a condemnation action by the government, will be given. If it's a lease, the tenant will be entitled to some of the condemnation award. But if it's a license, then the licensee doesn't have a property interest and therefore is not entitled to any compensation at all. Finally, and perhaps most importantly, a court will not give the equitable remedies of an injunction or of specific performance to protect a licensee. So licenses are only going to be eligible for damages if they're breached. Now, this means that licenses by their nature can always be terminated by the landowner, because no equitable or in specie remedy, such as an injunction or specific performance, will be given to protect a license. A license can be terminated by the licensor at any time. A licensor that terminates a license might be liable in damages for doing so, but that, remember, is the only remedy. And even then, damages will be available only if terminating the license breaches a contract. And so we have to look and see whether the license is based on a contract or not. Some are and some are not. So terminating the contract may not breach a license, and therefore there may not even be a damages remedy available by the licensee against the licensor. But at most, that is the only remedy that will be available. Now, what have we learned about licenses and leases? We've learned that it's critically important that judges and the parties know the difference and be able to tell which of those relationships is created by a particular agreement. So the moral of the story is to think through in advance whether you want a lease or a license. Generally, landowners would prefer licenses because they're easy to terminate. Generally, occupiers would prefer leases because they have greater security in holding on to possession of the property. The point is to expressly call it what you want it to be and expressly exclude the other possibilities. If you do, you can save a lot of money and effort in litigation. That concludes video number 22 about leases, contracts, and licenses. In our next video, number 23, we'll talk about the landlord's duties with regard to the condition of the property to the tenant. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.